record. All right. Good evening, everyone. Welcome to the webinar tonight that we're running with Houlihan Squared. Your rural business may be more valuable than you think is the topic we chose, because the value of your business can be increased with more assets that you have, and you might have hidden assets in your business. And that's why I've brought Houlihan Squared along tonight. We've got a couple of very educated ladies with us. So let me introduce them for you. So firstly, and you'll see her name on her video, Dr. Victoria Longshaw. Now, not only is Victoria a solicitor admitted in the Supreme Court, she's also got a PhD in biochemistry. And so she's a patent and trademark attorney and working at Houlihan Squared down at their Melbourne head office. And with her, we've got Dr. Carolyn Rolls, also from the Melbourne office at Houlihan Squared, also admitted into the Supreme Court as a solicitor, but the PhD is in inorganic chemistry. So again, so highly qualified, and both really looking at the intellectual property rights for Australian and New Zealand clients in particular. And that's why we wanted to focus tonight on rural businesses, because so many growers have lots of aspects in their businesses that they probably take for granted, but actually can have a lot of value and worth protecting and capitalising on. So I know that we've got some great case studies tonight that we're going to go through. Before we jump straight into it, I am recording this as well. So if you're watching the replay, you won't have the benefit of being able to ask a question live. You can email me instead at jackie@tbalaw.com.au, and I'll be able to flick that question on and we'll get an answer for you within a couple of days. Otherwise, for those of you who are live in the webinar or live on Facebook, please use the chat or comment function. I'll be checking that and coming back to that at the end, and we can answer your questions. But I am now going to hand over because these case studies are a lot of fun, and I want to hear from these very intelligent ladies about what we should be doing with our rural businesses. So let's hear from you.
Great. Oh, thank you. Thank you, Jackie. That was an awesome introduction. Wow. It's really great of you to actually invite us along here to speak to growers and people with rural businesses, because we think that this is really, really important. This is something that we care very much about. And so in case Jackie, as she was going through, in case you didn't hear us or see us waving, I'm Victoria, this is Carolyn, and yeah, we're from Houlihan Squared. We work with intellectual property, with patents and trademarks. We also work with copyright, but we'll be going into that in a little bit more detail. So first of all, I'm going to hand you over to Carolyn to sort of tell you why we're here.
Yes, yeah, we're really enthusiastic about IP. We love talking to people about their businesses and helping them to identify IP in their business, or perhaps more importantly, identify the value of the IP in their business. Unsurprisingly, most people focus on the tangibles of their business, the things that they can touch and see, like the buildings, the equipment, the products, and so forth. But intangibles like intellectual property can be overlooked. So what we would like to do today is firstly explain what's encompassed by the term intellectual property. And sometimes people are very surprised by what it includes. So we hope we can give you a few surprises in this talk. Then we'd like to firstly show you some things to consider when making decisions regarding intellectual property. And secondly, illustrate how IP can be used as an asset. And thirdly, point out possible pitfalls and traps that could stop you extracting value from your intellectual property, or things that might give a free kick to competitors. And we're going to do that through a couple of sort of very, as we like to think, fun case studies. Some IP may be extremely valuable, but people are often quite aware that IP protection can be expensive, and cost-benefit analysis is always important, obviously, in any business. We hope that we can help you, at least in some small way, to make informed decisions about intellectual property that will help and benefit your business.
Great. So yes, and on the other side there, we're not here to sell you stuff. Basically, if we've got a bit of a saying here that nobody likes to tell anybody that they've got an ugly baby, you know. So everybody's sort of very careful about it. But if you turn up with a your baby sometimes is your trademark, and you're sort of thinking about it, we'll tell you what's difficult. We'll tell you if it's an ugly baby, but we'll basically tell you what we can do about it, and sort of give you some solutions going forward. But there's no point in trying to sort of work with something when you could actually improve the value just by looking at things in a truthful way. So let's just introduce who we are. We are based in Melbourne. Our head office is in Melbourne. We do have Malaysian and Singapore offices, and also an office in New Zealand. So we make most of the decisions, and most of the instructions come from our head office, but we have people on the ground in these other offices. We also have a lot of a network of associates across most countries, including the Asia Pacific, but across the US and Europe, that where we don't have offices, we work directly with associates, and we sort of negotiate the best deal for people who need to file in those particular countries. Patents, trademarks, those are all governed by each country. So it's necessary to speak to a patent or trademark attorney in each country. So just to give you an idea of who started the firm, Elizabeth and Michael were the founders of the firm, and both being tech-minded, they didn't go with anything boring like Houlihan and Houlihan. We went with Houlihan Squared, which I can tell you has been great fun in domain names and emails, trying to explain that to people. But it's got this, that's one of the aspects of trademarks that we could actually talk to you about, is that's an inventive aspect of a trademark, having Houlihan Squared. One of our slogans is to think outside the square. Nigel Parker is one of our other partners. He came on a little while later, and he's in the biotech area, and he loves cycling and fishing. Michael is into his winemaking, and both Elizabeth and Michael keep bees. Their bees are actually extremely healthy, and we all get a lot of honey from them, not as often as we'd like though. Paul joined a bit later also, as well as Jim, Victoria, and Carolyn. So Paul's also in the biotech area. Jim and Carolyn are in the chemistry area, and I'm in the biotech area. But what we also do on top of this is trademarks, IP contracts, most things to do with IP. So even though IP is intellectual property is a specialized field, we also have to learn general skills across the board. So wherever we started, patent attorneys have technical backgrounds as well as the law background. So I'll hand over to Carolyn now.
Yes, so the obvious place to start with this evening is the question, what is intellectual property? And on this slide, we've listed some types of intellectual property and intellectual property protection. They're the ones that you're most likely to bump into. There are some other types, but they're a little bit more rarefied, and we're not going to cover them off this evening. But we will this evening be giving particular emphasis to trademarks because they are probably by far and large the most common form of intellectual property that you will have or you will use. So starting with the first one, patents. Patents are a form of protection for inventions. Inventions that have a technical aspect to them, you have to apply for protection. But if you can get a patent, it will give you a monopoly for at least 20 years for your invention. Now, we think of an invention as a solution to a problem. It has to be a technical type solution, and a patent protects the invention in terms of its technical functionality. An invention that's protected by a patent can't be a mere idea. The idea has to be reduced to practice, as we say. It has to be something that embodies the idea. So it could be in the form of a product that you can pick up and hold and touch. It could be something like a new device, a new machine, new apparatus, but it could also be something like a new method or a new process. And in some cases, something as, I guess, ephemeral as a IP software related invention, but it always has a technical aspect to it. Moving on from them, there's trademarks. Now, trademarks are completely different animals. They're indicia that distinguish the goods or the services of one trader from another trader. And they're actually incredibly powerful. I mean, who hasn't looked at, say, the word Mercedes and thought of the motor car, or looked at that 3-point star and thought of the motor car? That's an example of an incredibly powerful trademark. So when you're thinking of trademarks, think of words, logos, even aspects of packaging, sometimes colours and sounds in certain circumstances. All of those can potentially be very effective trademarks. People often ask us, what are the most valuable trademarks in Australia? And top of the pops in that sense is usually the trademarks belonging to the banks, the telcos, such as the Telstra trademark, and also big retailers such as Woolworths and Coles. But a really good trademark is instantly recognisable. So, for example, if you see that black and yellow pseudo Southern Cross that the Commonwealth Bank uses, you would never mistake that for the red W that the, say, Westpac use, or the blue ANZ logo. So patents and trademarks are probably the two most important types of intellectual property we'll talk about tonight. You can protect designs, the shape and configuration of a product, or the pattern and ornamentation applied to it. You can get registration for that. Many people are surprised by that. Copyright, which is very important, very powerful, protects usually creative works such as literary works, visual works, photos, artworks, paintings, sculptures, those types of things. And then there's confidential information. You may not realise that your product lists, your client lists, your methods for doing things, they're all important forms of confidential information. When thinking confidential information, think of all the things that you don't want your competitors to see. Then there's the get-up, the trade dress, the appearance of a product. A very powerful example of that is McDonald's. If somebody blindfolded you, dropped you in a McDonald's store and whipped the blindfold off, you would just know that you're in a McDonald's store before you even saw the big trademark that says McDonald's or the golden arches. And finally, perhaps a bit more obscure type of intellectual property protection, which is plant breeders' rights. If you come up with a new stable variety of plant, potentially you can get what's called a plant patent, which gives you monopoly over that plant and its reproductive material for up to 20 years.
Great. That's great. So we're going to sort of like we thought, well, we could explain this in a very sort of dry and boring way, but we prefer to do things a little bit more interesting. We had a lot of fun setting up these next slides for you. We came up with a little story for you to actually illustrate how these intellectual property rights interact with each other and how they can form the basis of your intangible products. So we came up with a little story of two olive oil producers, Mr. Plan Ahead and Mr. Sheil B. And we can see that they're both quite colourful personalities. And yes, so we're going to start off with Mr. Plan Ahead's story. Great. So Mr. Plan Ahead, as you can see, he's very chuffed with himself there. He has a family farm and an olive oil production business, and he has been developing, he's been using his family's age-old methods of production, but he's also been upgrading his methods. So this is, you know, obviously theoretical. So please, if there's any Mr. Plan Ahead out there, I'm not talking about you, but we'd love to hear from you if you're there. He has been updating his family's methods with new inventive improvements. Like, for instance, he's using new blades to cut the olives, or, you know, particularly slightly different temperatures in which to process the olives. And he's also gone ahead and designed a new bottle with a very different shape and a new pouring dispenser. So he's been a pretty busy guy. He has been experimenting with new plant varieties. So both sides of the coin, he's been either buying them or licensing them from other people who've already created them and planting them, and he's also trying to create them himself. And on top of that, he came up with a new trademark himself, which we thought was pretty clever, didn't we?
We did.
And then he paid a professional to design a logo, a label, and marketing material on top of that. So that's sort of his story, which goes on to...
Yes, well, here's a picture of Mr. Plan Ahead's product. You may see a wonderful new shaped olive oil bottle full of olive oil with a label stuck on it. What we see is a substantial bundle of intellectual property rights. We'd start off by looking at the oil inside it. Well, it's come from these new olive trees that Mr. Plan Ahead has been trying to develop. Potentially, he could get a plant variety right for that new type of olive tree that he's getting the olives from. He's got a lovely label there. You can see front and centre, Catto, with a pussycat on it. The word could potentially be the subject of trademark registration, and so could the pussycat logo. The label as a whole could also be registered as a trademark. That's an option. There's heaps of confidential information in this product, going to how it was made and the suppliers and all those things that I mentioned before, all the things that you don't want your competitors to know about when you're doing business. The unique bottle design potentially could be the subject of design registration. There's a new pourer up the top under the flip top. Now that could be the subject of a design registration because it has an unusual appearance. It could also, because it's a technical aspect to the product, could potentially be protected by a patent. And we may have mentioned that Mr. Plan Ahead has beefed up his process. He's improved the process for producing the olive oil. Potentially there's patent protection for the process. And finally, I'd mention copyright in the label. Copyright is convenient in the sense that it exists from the moment something new is created. So unlike patents and designs and, at your option, trademarks, you don't actually have to file an application to get protection for it. So that's Mr. Plan Ahead's product, his bundle of IP rights, and he can think about whether or not he wants to get himself some IP protection.
Right. And as you can see by his picture there, that's exactly what he's been thinking. he has gone ahead and filed a patent application for the new pouring dispenser on the bottle. And very importantly, he went and filed his patent application before he sold any of his products, or he put it on his website, or he told anybody about it. So he's a very secretive guy. He kept everything secret. Then he filed his patent application. So we love it when people do that, don't we?
Yes, we
Keep
do.
it secret.
Keep it
Yes.
secret.
He has also, he's not yet filed a patent application for his new inventive improvements. He's still working on them, but he is keeping them secret, and he's making sure that all of his employees know that this is very secret and they're not to blab about it to anybody down at the pub. He has filed a design application for the appearance of the bottle, so the different shape that he's sort of come up with, and that's for the appearance of the bottle. So we're not talking about the functional pouring dispenser. That's the part of and that falls into the patent arena. He's not yet filed any plant breeders' rights or plant variety rights application for his new plant variety, because what he's doing is he is propagating several generations of the plant to check that it's stable. And this is one of the requirements of plant varieties. And he's keeping that under wraps also. And where he is using his plant varieties that he's licensed, he's got his contracts in place. So he's got all the paperwork down. Yeah.
Yes. Now, further to Mr. Plan Ahead's plan of action, he had a professional designer who put together the logo. Now, very, very prudently, he had the designer sign a contract with him. And part of that contract was a promise that the designer signs a copyright assignment deed, assigning copyright over to Mr. Head or Mr. Head's business. Now, this is very prudent because when the designer created the new work, the Pussycat logo, for example, he immediately owned copyright in that new logo. And Mr. Plan Ahead has thought, if he owns that, that's not so good. So he's had a copyright assignment signed, and that has transferred the ownership, thinking ahead. He needed to do that because that might have impeded his ability to potentially file trademark applications. He's got the option of filing a trademark application for the word catto, for the logo of the Pussycat, or for the whole label with everything on it. Usually, if somebody is going to use a trademark on lots of products, for example, he might want to make catto his house mark and put it on other things that he might sell, like fresh olives or pickled olives. If he's going to make catto his house mark for all those, we'd strongly recommend trademark registration. Now, he plans to enter into agreements with potential distributors, possibly overseas, and he intends to sell products through Amazon as well. That's his plan of action.
So he's got some big plans going ahead. So let's just talk for a minute about what's so great about his trademark. Beside the fact that we both love cats,
yes,
we think it's an excellent trademark. Oh yes. It's, first of all, cats have got nothing to do with olive oil. So technically it's not describing olive oil, and that's what you want. So anything that describes what you're actually selling it tends to be called a descriptive trademark. And when you file a trademark application, the trademark office is quite quick to say, well, we're actually going to not let you have this, we're not going to let you register it because we think other traders should use it because they should also be able to describe their goods that way. But in this particular case, nobody else has to describe their olive oil as a cat. So that's what's so great about it. It's got nothing to do with it. It's likewise with an Apple computer. I mean, that's what makes the Apple trademark great. Besides the fact that it's enormously valuable, it has absolutely nothing to do with computers. So that is what you're going for, something inventive that doesn't have any particular link to what you are selling, the goods that you're selling. So as you can see, there's a little R next to Cato, and this is meant to designate that it's a registered trademark. You're only allowed to put the R with a circle when it's a registered trademark. You can still put the TM, I'm sure you've all seen that little symbol, the TM for trademark, to the top. The convention is to put it to the top in superscript. If you don't have a registered trademark, that's fine. That indicates that you're using it as a trademark. So when in doubt, it's always better to put TM, but Mr. Planahead can put an R because he's gone and got it registered. You can see it's quite unique. It's very different to his competitors' marks, and it hasn't got any reference to geographical names. That's also quite important because that can also be a descriptive element that other people from that region would want to also describe their goods with the geographical name. It also doesn't have words like great, great olive oil, or the great Cato, best or good, or gold class, or things like that. So those words are referred to as laudatory. So other traders are also allowed to say how wonderful their goods are. So that can also impede getting a trademark registration. So he can, in this case, he's filed for his word mark, his logo, separately, the little picture of the cat, but you can file for it together. So there's various aspects of a trademark that you can cover. And we generally have a look and say, well, look, we think this particular case, you should be just going for the logo for now, and maybe we'll try and have a go at the word mark later. Or in his case, he went for both and he was fine. So yeah, there's various options. So now we go on to our next character.
Yes, we have another olive oil producer, Mr. Sheil B. He also has a family farm and olive oil production business. His family have been using the same olive oil production method for many, many generations, but recently they've upscaled production and found some new inventive improvements to the process. In fact, they're so good that one of the staff, whose wife is a reporter on the local newspaper, has done a double-page spread on the business featuring the new process in great detail, and the article's been picked up by the Weekly Times. And that's particularly great for marketing the business. He's selling his olive oil product in a pretty standard bottle, that, circular cross-section, elongate one with a cork in the top. But he's lined up a really great supplier deal for the bottles. Now, his farm's planted with very old olive trees and imported from Italy, again, many generations ago. And he's heard that there's a few competitors, such as the Head family, who've been making their product look a bit more flash. So Mr. Sheil B. has hired a professional designer to come up with a trademark, to design a label and prepare lots of marketing material. And the professional's taken lots of photos of the old olive trees and included that in the marketing material. Very nice.
So you can see he's the kind of nice bloke we all get along with, but he's also, he's not particularly secretive, and as you can see from his face, he's a little alarmed at how few arrows we've got on his picture here for his product. He hasn't got as much in his intellectual property portfolio, but he has got something. So it's not totally the end of the world here. So he's got his bottle here, which he gets from his great supplier. As you can see, it's a pretty standard bottle, so he won't be able to file design applications for that. Not only did he not design the bottle, but it's a pretty standard one and it's already for sale. He's been buying and selling it. He does have a trademark. As you can see, he's got his label. I have to pronounce this properly because it's in Spanish. La aceituna. Is that correct?
I believe so.
Oh, good. Excellent. And that is, he's got Bendigo up at the top there and olive oil. And that's for anybody who can't tell that it is olive oil, but he is making sure that he's describing his goods properly there. So he does have copyright in the whole label. And he also has a trademark, which is the wreath of olive oil plant or vegetation, and Bendigo La Aceituna olive oil. So the whole thing is a trademark, as well as all the individual bits, the La Aceituna. He also has the get-up, all the colors, and the look of his label, and his confidential information, which relates to anything that's secret of how he's making it, and also the main, in particular, his supplier information. So what is his plan of action? He plans to keep selling his product. He would like to enter into agreements with potential distributors, possibly overseas. He really wants to expand his business and his operation overseas, and he would like to get online.
And let's take a look at the trademark situation. Now, Mr. Wright has not registered his trademark. He's using it as what we call either a common law mark or an unregistered trademark. See, he's flagging that it's a trademark by putting the capital T, capital M up in the top right-hand corner there. That puts people on notice that it's not just a decoration, it is in fact something he's relying on as a trademark. Now, is his trademark distinctive? This would become important if he decided to apply for registration. The trademark has to be distinctive to distinguish your product from the product of other traders. Well, it's not really that distinctive if we break it down. The word olive oil, well, that's directly descriptive of what's in the bottle, so that can never really function as a trademark on its own. La Aceituna in Spanish means olive oil. Now, you would think that because it's in Spanish, that would make a big difference, but not necessarily so, because there are Spanish-speaking people in Australia, a fairly substantial number. So it's unlikely that that would be considered sufficiently distinctive for trademark registration. The word Bendigo, well, he can't get any sort of monopoly over that because obviously every trader in Bendigo has to be free to use that particular word to describe where they are. And as Victoria alluded to, that wreath of olive leaves is not particularly distinctive because it's very commonly used in relation to olives and olive products. The other problem we have here is that he had a sort of handshake agreement with the designer who created this trademark. So technically, it's highly likely that the person that created the mark still has the intellectual property rights in it. When you've gone into a handshake agreement, it's, well, you might say, she'll be right, mate, but it might not be right. Hopefully, Mr. Sheil B will be able to go to the designer and get him to assign intellectual property rights. Otherwise, he may have a significant fetter on his freedom to actually use this trademark.
Yes, because, and just to add to that, any copyright assignment has to be in writing. So you can't have just an email saying, yep, you own it, you got it, or even a verbal agreement. So it has to be in writing. That's one of the requirements under common law. So let's, oops, gone ahead. A comparison, let's have a look at a comparison of the list of their tangible assets and their intangible assets. So as you can see on the left-hand side, Mr. Plannerhead's got a longer list than Mr. Sheil B, who's a little bit worried at this point, but we've got some suggestions to help him at the end of this. So as we can see, Mr. Plannerhead, he's got his real property, which is his tangible property. So that would be his farm equipment, his land, his anything that his business owns, which you will be very familiar with. But his intangible property is in his intellectual property. So at this stage, He has filed patents. He's filed one in Australia, one in New Zealand, and that's for the dispenser and on the top of the bottle. He's also filed a design for the shape of the bottle, and these are all registered rights. Registered rights are much easier to enforce than unregistered anything. Plus, he filed all of his applications while everything was still secret. So this stands you in good stead for the validity of your registered rights. He is also, he either has filed or he is licensing a plant variety right, and he's also filed his trademark applications, which are now registered in a few different countries where he's planning on actually expanding his operations. So he has filed his Cato mark, and he has a registration in the US and in China when he's ready to sell, which is a great way of doing it, because sometimes if you sell first and then try to register it later, that can actually, you can come a cropper in China. They're very sharp. So you really want to lay the groundwork and you don't want somebody registering your trademark and then trying to sell it back to you. So from the copyright side, he's got all the copyright assigned to his business. So he owns the copyright in his trademarks and also in any of the marketing material. He has, on the common law side, the common law rights, which kind of underpin a lot of his use. It's a very sort of layered aspect when it comes to trademarks. So you've got the registered trademarks, which is your first prize, and you also have the common law rights, which sort of back that up. He also has his confidential information and trade secrets, which emphasis on the word secret. He has kept secret, which relate to his new improvements to the method of production. Whereas Mr. Sheil B, unfortunately, mate, you've only got your copyright. You aren't able to actually file any patents at this point, because unfortunately that newspaper article has disclosed it. So even though he disclosed it, it can still mean that his invention is not secret anymore. So that's very important to note. Even if you go talking about your product and you say, well, it's only me talking about it, the patent office doesn't take into account who was talking about it or who published about it. So public disclosure in any way is a problem for filing a patent application. He does have some copyright in some of his, if he's taken photos. Was it the professional who took the photos?
Yes, it was.
Oh, yes. So he doesn't have the copyright in a lot of the things that he's going to have assigned to him from the professional who's got the copyright in the photos that they took, and also in the trademark that they developed and the marketing materials, the layout of it. So he does have some common law rights because he has been using that trademark and people have come to associate that with him. And he also does have some confidential information, which is quite valuable and he needs to protect. And that's in particular the identity and contact details of the bottle supplier that he's got an exclusive contract with. He really doesn't want anybody to find out about this person and contact him directly. There we go.
Yeah, so what does all this mean? Well, in this situation one that we've set out here, we're looking at licensing. Now, a license is a permission to work within the scope of an intellectual property right. And it's one very good way in which intellectual property owners can earn money off their IP. It's much easier if you have clearly enforceable rights. It's much more difficult if you have unregistered intellectual property. So if you want to have IP earn its keep, you are very likely to want to have some registered rights, patents, design registration, plant variety right, or trademark registrations. So in short, Mr. Plan Ahead has more options. We're not criticising Mr. Sheil B, right? We're just saying that it could be significantly more difficult. He'll have to be very canny indeed if he wants to cut some clever deals to make the most of what he's got. But as a general comment, his grasp on ownership of some of the intellectual property is tenuous, and licensing does rely heavily on the licensor having full ownership of what it is that they're licensing. It could be very trite to say you can't license what you don't own. So Mr. Sheil B will have to do some pretty fancy footwork.
Yes, and then just to add to that, the best kind of contract is one that both parties know exactly what they're getting into, and very clear, and so that nobody's going to argue about it and waste money arguing about it. The worst kind of contracts that you can get into are where one person thinks they're getting one thing and the other person thinks they're getting something else, and then they're likely to fight about it and waste lots of money fighting. So when we talk about clear enforceable agreements, a license agreement that can clearly point to a registered patent, which is a document that clearly sets out the four walls of what this invention is, or a trademark registration, which clearly says, here's a picture of the trademark. That is a very clear kind of clause to have in an agreement, whereas unenforceable agreements are ones where, for instance, say Mr. Sheil B has been tinkering with his trademark over time. So he actually has 5 different versions. So which one exactly is he licensing? So that can cause some problems. So just to go ahead to the next challenge for these two guys, now they're trying to expand their operations overseas. So when it comes to registered patents or registered trademarks, there are, and designs, there are certain deadlines that you do have to meet when you are filing overseas. So for instance, if you wanted to file a patent application in the US or in China, for instance, you do have 12 months from the date that you file it in Australia. It's a sort of grace period, really, that they sort of give you, that you don't have to make up your mind on all the countries that you want to file applications in immediately, because really, who knows exactly where they want to protect their invention, and it costs a lot of money, to be honest. You really want your intellectual property portfolio to be paying for itself. So for instance, Mr. Plan Ahead, he has already filed in Australia and New Zealand. If he did at that point, for instance, if he filed another patent, he would have 12 months in which to make up his mind whether to file overseas. When it comes to designs, he has 6 months. With trademarks, I'll just go over the plant variety rights. That's a particularly Australian thing. You can get patents, plant patents overseas, but that's a creature of Australia, isn't it?
Yes. Yes, you're better off here.
Yeah, better off here. So trademark registrations, you can file trademarks in any country at any time. That's a bit different to patents. But if you want to backdate it to the date that you filed it in Australia, you have to do that within 6 months. But all of these things are normally, when anybody comes in and we talk to them, we sort of lay out a strategy saying, well, when's best to actually file? And when is best to file is, number 1, it's still secret, and number 2, it's as near as possible to completion. So your invention or your design, you want to push out those deadlines as long as possible, and you want at the same time as much information about your invention as you can. His copyright is automatic, it automatically arises, and Australia is part of the Berne Convention, which means that it automatically arises in all countries. There's no need to register it. So Mr. Plan Ahead, when he filed his patents, designs, trademarks, it did give him opportunities to file in overseas countries. Whereas Mr. Sheil B hasn't got any registered trademark rights at this point. You cannot expand common law rights into other countries. Other countries are not going to always recognize common law rights from Australia.
Now, intellectual property owners are often very concerned about people copying their intellectual property. Whoever said that copying is the sincerest form of flattery clearly was not a patent attorney. We just view it as theft. If you don't have a license or a permission to use somebody else's intellectual property, then you shouldn't do it. And similarly, if they don't have a license or permission to use your intellectual property, they should not be doing it either. Intellectual property disputes in most countries, particularly in Australia, start with what we call a cease and desist letter or a letter of demand. If you receive such a letter, or if you actually need to send one to defend your intellectual property rights, we suggest firstly consulting with a lawyer such as Jackie. This is particularly true in a case if you're considering sending a letter of demand, because making an incorrect assertion under any of our Australian intellectual property statutes can actually end up with you in almost more hot water than the person that's infringing your intellectual property rights. You can make your position very bad. So it's also true that in some situations, a formal letter like letter of demand might come across as overly aggressive. So a softly approach is sometimes better. A polite email can often do the trick, but do make sure that you keep a record of any interactions with other parties and such matters as a record for later on. In the vast majority of intellectual property stoushes, the parties enter into discussions or perhaps negotiations and sort it out. Frankly, very few intellectual property stoushes end up in the Federal Court of Australia. And that's the way it should be, really. But in general, if you are drawn into an intellectual property dispute that involves lawyers and courts, being able to point to a registered right adds gravitas and clarity, and it can provide a form of leverage over another party. In this case, you can see that Mr. Planner Head, if he wanted to pursue infringers, would be in a pretty darn good position. Having enforceable rights also is the key to some very specific forms of protection. Most countries, including Australia, have customs seizure provisions that are reliant on you having a registered trademark or a patent or a registered design. And customs can actually stop goods coming into the country if they're copying. And other countries, such as China, for example, you may be surprised to know, has very strong customs seizure provisions for infringing goods going in and out of that country. But it's always pivotal that you have a patent or a registered design or a registered trademark. And finally, if you are concerned about people using online platforms who are copycats, most of the large organisations such as Google and Amazon will do have provisions for taking down certain websites and stopping certain activities that are infringements of intellectual property. But they invariably require that you have a registered trademark, and for specific goods, sometimes they require that you have a patent or a registered design. So just keep in mind those potential weapons, if you like, for using against copycats should they pop up.
Yep. And to that, would just add that, we both love doing DIY things. We do a lot of DIY, probably a bit too much, but a cease and desist letter is definitely not a DIY thing. You can get yourself into some hot water with that. It's always good to have as much information as possible, but yeah, before writing anything to anyone, you don't want to get yourself in hot water, and you want to line your strategy up very well to spend as little as possible and take the correct strategy to get the outcome that you're looking for. So I would also say to Mr. Sheil B, if he does receive a nasty letter, so never mind necessarily just sending out nasty letters, he hasn't got any registered rights. If he had a registered trademark, that is an absolute defense against trademark infringement allegations, not necessarily against other sorts of allegations, but at least it would hold off trademark infringement allegations. So that would be great to have from a defensive position. But also, if he did get a nasty letter saying that he is infringing something, we always tell people, don't panic. Sometimes some people, we've seen some doozies, haven't we?
Oh, yes.
And we've had a good time going back to them saying, yeah, you actually don't have any rice. So thanks for coming. And we've managed to chase them off the grass that way. So don't be afraid when you do receive a nasty letter. It doesn't necessarily automatically mean that that person has a good case.
It doesn't mean that you're going to be in the Federal Court of Australia next week. That happens on very bad American law programs.
Yes,
doesn't happen here.
Programs on TV. So assisting Mr. Sheil B, right, he's looking a bit worried, but it's not too late to get his copyright assigned. He can also still file a trademark application. You will have to probably provide evidence of prior use. This is one way of getting a trademark application across the line. It is likely that a trademark examiner will say, hey, you can't really have this application because, this trademark registered because it's descriptive. But one way of showing that it's not descriptive is to show that your customers already know that it's associated with you and your goods. So you can provide evidence of prior use. So we would have to show several invoices over time, his advertising, even that a newspaper article might actually help him get the trademark application, even though it nuked his chances of getting a patent application. Anyway, the shortest time that you could probably get a registered trademark across the line is 7 months. The trademark office is not allowed to give it to you in a shorter time than that. They might give you notification to say, well, we don't find anything wrong with it, but it's going to take at least 7 months for you to get a certificate. So if he has copycats coming in, he will be in a stronger position if he did get his registered trademark through. I know it might be a bit of a delay of 7 months, than to try and write to them now and say, hey, I've built a reputation in my common law mark. It's just a weaker position to be in. So we could try other things like, getting his application through in order before actually writing off a letter. If he does make any further improvements, we would tell him to keep them secret, take a leaf out of Mr. Head's book and keep them as secret as possible. And then he can decide whether to file patent or design applications. He might decide that he doesn't actually want to file patents or design application, and that's fine as long as he's actually made that decision for his business at the right time and not after the fact. So he can also set up confidentiality agreements with his employees to make sure that his supplier information is not blabbed, so that anybody who knows about this information, first of all, it's under lock and key, it's under password protection on his computer, and the people that have access to it know that it's secret and that disclosing it would cause him damage. So that's very important to set up. So if Mr. Sheil B Wright went back to the beginning, what tips would we give him?
We would give him these tips, Victoria.
Tell me.
We'd be telling him, choose your trademark carefully. Well, very first thing we'd tell him, yes, is beware business names, company names and domain names are not the same thing, and they're certainly not the same thing as a trademark. A really prudent person will, if they can, make sure that their business name, company name, domain name and trademark all line up. That's optimal, but that's rarely achievable. Do choose carefully. Be very aware of indicia that other traders will want to or need to use on their products. So be careful of geographical names, because other people will need to use those geographical names if they're in that area. What we call appellations of origin. You'll probably have all heard of things that we cannot use anymore because they're, let's say, native to another nation. We can't use champagne for sparkling wine anymore because we're not in the Champagne region of France. That's an appellation of origin. And there are many, many more for all sorts of food and drink and other things. Careful of descriptive or laudatory marks. You can't have fantastic for olive oil. That would not be registrable. Pretty fun, but ultimately it may not be good intellectual property protection. And steer clear of marks that are are the same as other traders or similar to those of other traders. It's best to distinguish yourself. Inventive is definitely best. Products of your own intellect are the best thing going. And think ahead. Consider whether your business is going to expand overseas, whether you're going to send goods overseas, and think whether you need intellectual property over there for your goods, and also be mindful of the fact that you don't want to infringe the intellectual property of other people in other countries too. So a lot of forethought required there.
And then just to make sure that you use the trademark symbols properly, so R for registered trademark, that's only when you've got a registration, otherwise using the TM. Even if you have not got a wonderfully inventive mark, or you're basically stuck with the mark that you've been using in the family business for ages, that's fine. If you keep records of use of the mark, it is possible that you could still get protection for that, showing that you have actually developed a reputation in them. And for your inventions and designs, keep them secret, keep them safe until you've decided whether or not you want to file patent or design applications for them, or keep them secret. And that brings us to any questions.
Wow. I've learned a lot too, ladies, really. Things that I've noted down, particularly the copyright assignment having to be actually in writing and not just via email. That was great to know. Also, the customs seizure, that was quite interesting, particularly China, because we seem to have a lot of rip-offs coming out of China, or vice versa. So yeah, really interesting. I suppose that might be a generalization from years ago, and maybe it's not so much, or they're moving into more legitimate practices. And also it's a bit more obvious about using a location in your name. And so for a lot of businesses in this area, if they use Goulburn Valley or something like that, it's not really great. But I didn't realize that, like, a symbol that is pretty obviously associated with that industry or that thing might also not be registrable. And I was just thinking, you know, in terms of law firms putting the scales, you know,
Oh, yes.
everyone used scales. Yeah. So, so that was really interesting too. And yeah, I also took a little bit more note of the cease and desist issue as well, because people can get quite emotional even when they come to us, and it's not, you know, it's not my law firm's area, and it's certainly something that I'm probably not going to touch if people do come to me for something like that again. I think people, well, the last couple have really been employees who have left that haven't kept information confidential. So I think that that was a little bit more clear cut, but using other marks or similar branding or names, I'll be far more careful about when people come for advice on that too. So really great points. We haven't had anyone put anything in the comments. We've had people ducking in and out of Facebook. So that's been pretty exciting. They've sat and watched some of the bits about our Sheil B analysis. So that's really good. But just to remind people, if there are questions, particularly on the replay, please email them through to me, Jackie at TBA Law. And we will get answers to you, you know, within reason. So yeah, I think that that was brilliant. I'm going to stop the recording so that we can have a little bit of a chat off the recording. And yeah, I hope people really enjoy this replay, and please don't be afraid to reach out and ask a question.